SJC-12165, Commonwealth v. Stanley Sharris, Jr.
Thanks. Mr. Rudolph, good morning.
Good morning, Chief Justice Gantz. Good morning, Your Honors. May it please the Court, Paul Rudolph on behalf of the petitioner, Stanley Sharris, Jr. 23 years ago, it's been 23 years since Mr. Sharris was first charged in this case and first declared to be incompetent. And there's absolutely no dispute here that Mr. Sharris will never attain competency. Yet he continues to live his life under the dark cloud of this indictment at the age of 74, spending his days in a hospital bed at the Shattuck Hospital with a feeding tube permanently attached to him, so weak that, if need be, medical personnel can restrain both of his hands with one of theirs.
Can I ask one before? He's been violent. When was the last time he was violent? Because it's not just the murder we've been dealing with. He was violent under care, right? A number of times.
Yes,
and groping and other things, right?
Yeah, it appears from the competency evaluations that are in the record, the most recent being a 2015 competency evaluation from Dr. Carroll, that there were incidents throughout his hospitalization when he was still at Bridgewater where he would be assaultive or argumentative, largely as a result of his cognitive impairments and his dementia. That, according to Dr. Carroll, either stopped or certainly got to the point where he was no longer dangerous, did not require the strict security of Bridgewater, I would say at least 4 years ago.
So he can't stab someone with a needle now or anything like that?
He's so weak that he can't walk on his own. He can't, he needs a feeding tube because he can't swallow.
I don't mean to distract you with this. I'm just trying to understand it, but go ahead.
Right.
Sorry.
And it was determined that his, it's an important question because it, of course, goes to the question of the public safety interest. But they've determined that he no longer requires the strict security of Bridgewater. He was released on personal recognizance with the conditions that he now can reside, excuse me, at the Shattuck Hospital with DMH following his care.
But for his medical condition, he could be free.
He is still subject to commitment proceedings.
Right, but so under the statute, he has a right to challenge his guilt or innocence, correct?
He has a right, he can't go to trial, he's incompetent.
Well, I know that. He has, under Section 7, he has a right to adjudication, right?
Under Section 17B, is that what you're referring to, where he can request? He doesn't have a right. In fact, it's at the trial court's discretion to conduct a 17B hearing. And there are significant limitations on the kind of on his ability to present a defense at that hearing. So,
and he has a right to bail, which he was allowed.
Correct.
So what you started with is the dark cloud of indictment. That's really what we're talking about here.
Yes, and what this court has said, and what is not just theoretical but tangible in this case, is that the mere pendency of charges does implicate substantial liberty interests. And I say it's not theoretical.
What about the Commonwealth's rights in this case, or the victim's rights in this case? Where does that come under?
So I think that can come into play in a couple of different ways. I mean,
we have an unadjudicated murderer, right?
Correct, and one that will never be adjudicated, and both parties agree to that. So Mr. Sharris will never have the ability to go to trial in this case. And sections, if you accept the principle that I think this court has already accepted just this year in Commonwealth versus Calvaire, that Section 16F, which governs when and whether a criminal charge for an incompetent defendant must be or can be dismissed, that implicates fundamental liberty interests such that strict scrutiny is required. That's what this court said in Calvert. If you accept that principle, which I think is a fairly non-controversial principle, then the question is, does he have a due process right to dismissal at some point? And that's a harder question, I think, which is, what is that point? And
Because when you're dealing with being in custody for years, when you're incompetent, as a matter of due process, that's a different level than when you are being not held. You don't even have a Section 7 and Section 8 anymore, but you have the cloud of the indictment still over your head. So when we're looking at what this due process analysis is, we're not looking at somebody who's in custody, and we're taking into account that murder is different, and we see that for different statutory reasons, and now you have to just look at the nature of a murder and the issue of due process when you're talking about somebody who's been charged, not committed. That's the balance we're looking for.
There's no question that there is a greater restriction on liberty for somebody who is committed or somebody who's detained. But there is still a significant impingement upon liberty interests for even where one is not detained or committed and there is a murder charge pending. Not just because it affects reputation, not just because it affects one's emotional and mental well-being, which could be important for somebody who suffers from mental illness, but because it can affect practical, real-world ability to live life. And for Mr. Sharris, this is not theoretical. The Department of Mental Health would like to be able to place him in a nursing home. Instead, he's going to live the rest of his years of his life in a hospital. And for a very ill 74-year-old man who is so weak and doesn't pose any significant danger to the public, he should be allowed to live the rest of his years of his life in an appropriate
And I understand
residential nursing home.
the policy argument, and I just want to get to the last sentence because of the statute for a second, because if you don't seem to, the last clause of the statute the last sentence reads, on the final date of such period, the court shall dismiss the criminal charges against such person. Here's the part I'm interested in, comma, or the court in the interest of justice may dismiss the criminal charges against such person prior to the expiration of such period. You're not arguing that this is open-ended, that this provision applies in murders? Are you?
Yes, I am arguing that it applies in murder cases.
Well, are you? Because I read your brief to suggest that you sort of agree with the Commonwealth that this provision, because of the words period twice, doesn't apply to first-degree murders. But did I misread your brief on that?
That certainly wasn't my intention. I agree with the Commonwealth that the prior provision, the mandatory dismissal provision, clearly exempts murder charges, but I don't agree with their reading of this second provision because I think it is.
So you read,
I think it's
and I'll stop interrupting you, I apologize,
Okay.
but so you read this last clause to provide an open-ended sort of in the interest of justice process.
Yes, and if I could explain why, I think there are a number of reasons. First of all, it is entirely possible that the legislature's intent here was not to, as they did with the mandatory dismissal provision, not to tie sort of an interest of justice dismissal to parole eligibility, but simply to say reaching that parole eligibility date is not a prerequisite for dismissal, that charges can be dismissed even if one doesn't reach a parole eligibility date. I think you could also look at it in this way, which is to say that if one reaches the maximum possible date you could serve, certainly at that point, the charges have to be dismissed. And the Macdell brief points out that Section 16F technically might not apply to somebody charged with a crime that carries a maximum sentence of 30 days in the House of Corrections, because there's no parole eligibility for such an offense. But I would hope we would agree that that charge has to be dismissed at some point.
But
But my point about that, Justice Kafker, is that even if we say, okay, the maximum possible time that somebody charged with first-degree murder could serve is life, in other words, until they die, the interest of justice provision provides trial court judges discretion to dismiss that charge before they die.
What does the trial court judge do? There was a few of them on the bench right now. What's the magic date? Do I have a different date than Justice Lowy may have or Justice Gantz did on a first-degree murder case?
Well,
do I think it's 10 years, 5 years, 20 years, 30?
if you're talking about the interest of justice provision, there is no automatic date. That is.
So if you appear in front of me, I've got a 30-year thumbnail, and the next judge has a 40-year, and the next judge has a 15-year?
Under the interest of justice provision, I would say that the date is not the only factor. It's one of many factors that a court
No, we're still
can
dealing with people who are incompetent who cannot be competent.
Yes.
Okay.
And what I would say is, as I argued in my brief, I think there's one way to interpret the statute. If you agree.
And then it's abuse of discretion for us, right?
Under the interest of justice standard, yes. But I would say that there are.
One judge has a 20-year, another judge has a 40-year.
I think it would depend on the other factors and how a judge considered them. And I think one of the factors is the duration of the pendency of the charges. Another factor is the likelihood of attaining competency. I think a third relevant factor is the.
Either way, if someone has a likelihood of obtaining competency, it's a different ballgame.
Right, but I think there could be circumstances in which somebody's been incompetent for 15 years and the doctors are still saying there's some possibility that this person could be restored to competency. There's a new drug coming down the line that might benefit this person. There are other circumstances where there's no possibility, everybody agrees there's no possibility this person's going to become competent. But again, that's not the only factor. I think the court also needs to take into account.
But isn't the issue that Justice Gaziano raised, that's actually present in anything but murder, right? Because that final clause does give trial judges the ability to shorten the time frame in the interest of justice in all those other cases expressly, right? In anything but murder, if this applies to murder, then it's open-ended, but if it doesn't, it clearly applies to all other crimes, right?
Yes,
that a judge could give less time, and we could have one judge giving less time, significantly less than others, right?
That's correct. And, Justice Sanders in the Giunta case, which this court cited approvingly in Calvert, dismissed life felony, not life without parole, but a life felony prior to reaching the 15-year parole eligibility date. Another judge may have disagreed. And I think it would depend upon the judge's assessment of that amount of time, the likelihood of.
I ask you
being
that same question you're addressing, though, in terms of due process, because my sense is that your due process argument is a stronger argument than your statutory argument, and wondering how this would work, because with somebody who's found incompetent, you've got a Hatch hearing, a 17B hearing, and there has to be a Section 7 and 8 to stay committed after a very short amount of time. What I'd like to understand is there something going along the lines of Justice Gaziano's question in context of due process, where there's a certain point in time in a certain circumstance, and we'd be able to articulate some sort of doctrine that it's rising to the level of a due process concern despite it being murder, despite the DA not being able to follow the person, and everything else that flows from a murder charge. Is there some way to articulate that doctrine that's limited in that regard?
The first thing I would say is this is that case.
Okay.
In the circumstances.
And how do we
of
say
this
that
case.
if we think there is a liberty interest, and that the liberty interest is so strong when somebody's 74, can't get out of bed, incompetent, never going to be competent? How do you deal with the Justice Gaziano question in the due process?
So I'm not sure that you can completely separate the statute from due process, because I think you have to decide whether I think you have to interpret the statute in a way that is consistent with due process. And I think there are a couple of approaches. I think one is interpreting the interest of justice provision as applicable and giving judges the ability to look at these various factors, including the risk to public safety, taking into account the availability of Section 7 and 8 commitments. Another way to do it, which was my first suggestion in my brief, which is do exactly what you did in Diachenko, which is if you look at the statute, if you're looking for a definitive end date, what really renders it unconstitutional, assuming, Justice Lowy, that due process does apply, what really renders it unconstitutional is the without parole language in Chapter 265, Section 2. That language, which this court found in Diachenko, was unconstitutional as applied to a certain class of defendants, in that case juvenile, I would suggest is unconstitutional as it applies to this class of defendants, which are permanently incompetent people. And if that's the case, the court can do here exactly what you did in Diachenko, and what the legislature said you should do if language in the murder statute is unconstitutional, as applied to this group, which is excise that language and then apply parole eligibility after 15 years for a crime committed back when this was committed. And so for purposes of interpreting Section 16F as applied to permanently incompetent
Why would you
offenders-
pick 15 years? Why is it not 30 years? I mean, why do you come up with 15?
Because if you take out the without parole language in the first-degree murder statute, what you're left with is life with parole at the time of this offense after 15 years. That's exactly what this court said. That's why you came up with 15 years in Diachenko.
So it'd be a different amount for a murder from this point on, you're saying?
It would be. And of course, the legislature could respond and rewrite the statute in some way and say, okay, we agree that now that the SJC has said a murder one charge has to be dismissed consistent with due process at some point, we're going to set a point.
Why is it ex post facto? Why is 15 years the magic number if we were to adopt your Diachenko argument? It's different than Diachenko. We're dealing with somebody not competent. And so we're trying to, if we deal with your argument, there's no ex post facto issue, so it's not necessarily 15 years by definition.
Well, I think you would look at the statute at the time that he was charged.
Have to, because it's not an ex post facto issue.
Well, I would suggest it is, because you're still talking about the statute that defines punishment, and that's the whole basis for the legislature's decision to determine when somebody is entitled to automatic dismissal. So I think when you're construing a punishment statute, you do have to construe it as it was at the time. I see that.
Two questions.
Sure.
If we were to do what you say, and if the person miraculously were to regain competency, I assume he'd still be facing life without parole.
Yeah, as a punishment, yes.
Punishment. So this is only for purposes of incompetency.
Absolutely. I'm saying it's unconstitutional as applied to incompetent defendants.
Secondly, what happens now if you're charged only with a mandatory minimum with no possibility of parole, but a fixed time period? How does it work?
I mean, I think most charges that carry mandatory minimums also have parole eligibility at some point. The parole eligibility may not.
Why it's a mandatory minimum?
Well, there's a mandatory minimum, but you still may be eligible for. There's a maximum. I mean, and we really look at.
Oh, if you do, so you would say that the parole eligibility date is the date of the minimum mandatory?
I think it's an interesting question because the legislature in Section 16F chose to define parole eligibility in a way that it doesn't actually, it's not the real way it works for a sentence that's served as half of the maximum potential sentence. So I think it has to be the way they defined it in the statute that governs that situation.
And what do we do with rape where I think the maximum is life?
I think you do what my understanding trial courts have done, which is apply 15-year parole, require dismissal after 15 years, because that is when one is eligible for parole. So that's my understanding of what trial courts have done. I see that I'm out of time, but I just want to be clear. I think it's apparent that whatever this court says in this case, and I think there's an obvious concern about this, will have impact beyond just Mr. Sharris. However, I'm here for him, and I would urge this court to understand that in his unique circumstances, a man who's 74 years old, who's very ill, and who should be able to live the rest of his years in a nursing home and not in a hospital, that this court will find a way to grant him relief and find that due process does require the dismissal of these indictments. Thank you.
All right. Ms. Ort-Gaskell?
Thank you. May it please the court, my name is Heidi Ort-Gaskell and I represent the Commonwealth in this matter. General Laws 123, Chapter 123, strikes a balance between the rights of the accused and the interests of the Commonwealth, as noted by this court in Hatch, where it said, I quote, Massachusetts General Laws Chapter 123-16F balances the interests of an incompetent defendant in dismissal of pending charges with the interests of protecting the public and enforcing the law by providing that the charges may remain pending for a period determined on the basis of the single most serious charge and the maximum sentence possible thereof. In this case, we are dealing with a murder indictment, and the maximum that a defendant, if convicted of murder in the first degree, could receive is life without the possibility of parole.
This case just makes, it's a great case in the sense that you're testing the principle, right? You agree he's incompetent, right? And irretrievably incompetent, right?
The Commonwealth previously agreed that the defendant is incompetent.
And it appears that he's no longer dangerous because he's physically a wreck. Correct? Or do you guys disagree with that part of it, that he's still... I'm just trying to understand whether we're in the situation where we have a permanently incompetent person who's no longer dangerous, so that we know we're testing the outer limits of this.
In this case, the Commonwealth agreed in the motion to dismiss that the defendant will never regain competency. As for his physical ability, at the moment, we do not have his medical records past 2015. So I cannot stand before you today and say that the Commonwealth believes he's always going to be physically frail or never can harm someone again. Because at this point, I can only rely on what he was in 2015 when a feeding tube was inserted.
What's the Commonwealth's interest in this so-called dark cloud of indictment remaining on an incompetent defendant?
The Commonwealth's interest in retaining the indictment on a murder defendant charged that's incompetent is really, it goes to the heart of what the DA's role is in the community. The DA's role in the community is to simply protect the community and to fight for justice and advocate for its people. When a murder occurs, it's not like any other crime, as Justice Lowy previously mentioned. A murder is very different. A murder hurts not only the victim's family and the family and friends, but the murder seriously impacts the entire community. When a life is taken, the employee, the employer, the neighbor, down the street, people are no longer feeling safe where they live. And the legislature has instructed and mandated, that is the DA, that he or she must be the ones that reaches out to the community and advocates on their behalf. In keeping an indictment open, as in this case for a murder, it allows the DA to fully participate in the civil commitment to know where this defendant is at all times and to be aware of what his future potentially holds.
There's a debate in the briefs about whether you're both overstating your positions about the DA's awareness. What is the DA going to lose by not having the indictment here, given where we are? If we do find this principle applies and that somehow you can dismiss the indictment at a certain point, you won't be alerted to anything, or what?
Under 16D, there's some ambiguity as to whether or not the Department of Health would still be required to alert the DA's office as to any future hearings that the defendant would be held for civil, and the DA would no longer be a party, so it's unclear as to whether, even if the DA was alerted to future hearings, if the DA could present evidence. And in such a case as this, where the defendant actually has a very violent history prior to his murder indictment, the DA is the only one with that information that can present that to the district court judge in his civil commitment hearings, and to give the full picture of the defendant's history.
Would it change your view if we said that the DA must be given that opportunity?
I think that would be helpful. I don't think it would change my view, because while it may help, in this case, a 74-year-old man who, in all intents and purposes, appears to still have his feeding tube, this is a very sympathetic defendant, and the Commonwealth is urging you not to look so much at the frail condition of a 74-year-old man who committed murder in his 50s, but to look at what happens when we have a 20-year-old who is deemed incompetent, and 15 years later, he's middle-aged, and he's not frail. And if we're giving the courts, the judges, an opportunity to read 16F as to have a mandatory 15-year dismissal period, then that is a serious problem. So the Commonwealth is not just looking at it from the Mr. Sharris perspective, but all defendants that are indicted defend.
It's not necessarily a mandatory 15-year dismissal period that's being advocated, though. And I'm not sure there's an ex post facto issue. But in that situation with the 20-year-old, obviously you make a good point about concerns of what murder does to society as a whole and the individual. But to hold the person, there still has to be a Section 7, Section 8, there has to be finding a dangerousness. So we're not talking about whether that 20-year-old is going to get out or not. That's not really what the discussion's about. The discussion is about whether or not the murder indictment is dismissed.
Correct. And I think even in that case where the 20-year-old would be civilly held, the community at large still has an interest, and it's the DA's role to advocate that interest in making sure that a murder, because it is so different and it is so horrendous and it impacts the community in such a large degree, that we don't lose the opportunity, should someone ever regain competency, to pick up where we left off in that case.
Okay, that's a fair point. What if there's a determination by the court that somebody's never going to regain competency, and the DA is going to get notice of what happens, and we're not dealing with whether somebody gets out, but whether or not the indictment remains?
And I'd resort to my previous answer that in other cases where we're dealing with an assault and battery, or we're dealing with a rape, which is still a life in prison, it has parole. Murder is different. It is treated different. It has historically been treated different. The legislature treats it differently. And so the community has a right to have that indictment pending. The community has a right to say, I know you're incompetent, but if in the large scheme of things, even though a judge said you're never going to be held competent, these are the types of things that I know that judges are extremely bright people, but you're not medical doctors, and you rely on medical doctors, and even medical doctors sometimes get this type of diagnostics analysis wrong. And so in a murder, to then not have anything hanging over someone's head, and they're civilly committed, perhaps they've been 17, as in this case, under Section 17, they're allowed bail, so they're not criminally held anymore. All they have is a civil commitment. At that point, if there's no indictment over a murderer, then there's nothing left for the community to step back in. There's nothing left for the DA to really advocate.
Is the dismissal under 16F a dismissal with prejudice or without prejudice?
So far, that would be a question for the court to answer. So far, it seems that it has been only litigated in the sense of with parole. And so when you reach that with parole period, you cannot then bring an indictment. So for example, in an A and B, once you reach the parole period and an incompetent defendant is dismissed, as in the Calvera case, we could not then bring an additional indictment because it's never been tested. In this instance, with a life without parole, those bounds have never really been tested. I would suggest that the court should do it without prejudice if it determined that that was in the interest of justice, because murder, again, is different and there is no statute of limitations. We can bring an indictment at any period.
And that would give you the chance to bring it back if lightning were to strike and he were to suddenly become competent.
It would, but again, then we'd have to start the entire process over again, and that would put us a few steps back. And, you know, then the victims would have to go through that entire process again, and the community would have to go through that entire process again. And you're talking about an additional grand jury and bringing witnesses in, and that's a very lengthy.
Oh, you just bring the same, you could present the same evidence. You could have the transcript of the previous grand jury presented to the new grand jury. It's not that big a deal. I mean, you could.
Yes, but again, explaining that to these victims as they come in, it's very difficult.
They might not have to come in, is what the chief is suggesting.
No, but for the trial.
Oh,
But those were all very good points. Murder's different. This is there's a lot of serious issues on your side as you're balancing these issues. But when you're looking at the level of scrutiny that needs to be applied to the statute without the possibility of dismissal, what if it wasn't 15 years? What if there had to be an agreement between the Commonwealth and the defendant that the person is incompetent and a determination that he or she is no longer dangerous? How does that balance work then?
If I understand your question correctly,
Yeah.
you're asking as if
Constitutionality.
the constitutionality of
Yeah.
whether or not the court can order the defendant to almost come to some sort of plea agreement, almost, but not quite.
Why would it be constitutional not to dismiss the indictment
Okay.
if there's a determination agreed to by both sides that the defendant's never going to be competent? It's more than X amount of years, let's say 15 for the sake of argument, and there's a determination by the court that the person's never going to be dangerous. Is the statute still constitutional in not providing the possibility of dismissal in a first-degree murder case?
The answer would be yes, the statute is still constitutional. To expound upon that, you're looking more at the due process analysis under Jackson v. Indiana at that point, which both of us cited in our briefs. And Jackson v. Indiana does not apply to this case because it only mandated that a due process analysis requires that an incompetent defendant cannot be held past the time that an incompetent defendant is held solely, and I emphasize that, solely due to his incompetency. In this case, if you look at the Massachusetts statute, there is never going to be a situation where a defendant is held solely due to his incompetence. And that is because, unlike Indiana, Massachusetts has incorporated our civil commitment standards into our hearing for incompetency. And so a person must, in order to be held for incompetent prior to trial, a defendant has to be not only incompetent, but also must be have a serious likelihood of harm. That's very different from the Jackson v. Indiana case. In Jackson, you had a defendant who stole approximately $10. You did not have a murderer. You also had a defendant who would have been released had he been held, because he was not, he would have been released but for his incompetency. Because in Indiana, the statute for civil commitments would not have confined him. So here in Massachusetts, you do not run into those same due process concerns. And the statute has
Yeah,
the
we,
entire
we not,
statute.
we not only have that, but we also have the 17B process, which allows him to, if he's innocent, vindicate himself.
Correct.
At least gives him a chance to.
Well,
Correct.
under 17B, what is the standard? The standard speaks of, finds a lack of substantial evidence to support a conviction. Is that a directed verdict standard?
The court in Hatch specifically specifically dealt with the standard and what level the burden is on the Commonwealth. I would say it's actually greater than a directed verdict standard. It's not simply a sufficiency. There is a somewhat higher burden on the Commonwealth in that
Justice
standard.
Spina's postulated on that for pages, right?
Yes. Yes.
But it's short of proof beyond a reasonable doubt, I assume.
It's short of proof beyond a reasonable, it's somewhere in between, but it's short of proof beyond a reasonable doubt, and it is greater than a directed verdict. It's not sufficiency.
So in the ballpark of a preponderance, or is that not said?
Preponderance is not said, and I think it's because it's criminal and they don't want to import a civil standard into it.
They read it backwards from the beyond a reasonable doubt standard, right? It's
Yes.
substantial evidence to support a finding of beyond a reasonable. It's complicated, but it's not a directed verdict. It's much higher than that.
It is
isn't
much higher than that, yes. And to go to, if I may, the 17B standard, to fully answer your question, the defendant in this case has not requested a 17B hearing, so there's no indication of whether or not a judge would allow it, because 17B is at the discretion of a judge. But a 17B hearing, as Hatch tells us, would allow the defendant, even though he is incompetent, to call forth witnesses and cross-examine. It also has really no risk to the defendant, because if he wins, the charges go away. But if he loses, he's still incompetent, and we still have to.
Is a 17B dismissal with prejudice or without prejudice?
My understanding of 17B is with prejudice.
With prejudice.
Okay, thank you.
Thank you.